the same file that Judge Lott had looked at in camera for Brady and found nothing, and Judge Anderson, then D.A. Anderson, had indicated there was no exculpatory evidence. Bill Allison, a great lawyer, had the forethought to ask that be sealed for the appellate record, and it was done. Many years later, we come to find out that instead of the whole file, which was a lengthy quote, almost the size of a telephone book, there was one sheet of paper in there.
There's a line in the transcripts at a pretrial where one of my attorneys got the judge to directly ask the prosecutor if he had any other exculpatory evidence that he had not turned over. And he looked right at the judge and told him no.
Some things that Ken Anderson did were kind of typical, and that is doing your strategy as far as not having to disclose any more than you had to. If you had a weak witness, you thought, but particularly had offense reports, you just as soon not have the other side see. A lot of prosecutors would not put that witness on so that offense report wouldn't be tendered. That's what happened partly in the Michael Morton case.
I'm driving along and my cell phone rings. It's Rosemary Lindbergh, the DA from Travis County. She said we took it upon ourselves to test the DNA evidence that was found on the bandana on a cold case we had. And I said, well, I don't understand why you're calling me. Why aren't you calling the Williamson County DA's office? And there was a pause, and she said, well, you know how they are. And I said, well, I'm finding out. I'm gonna get to my office, I'm gonna get a court reporter, we're gonna get a record.
I learned about the exculpatory evidence being suppressed quite literally just a couple days before I got out of prison. In my situation, the Innocence Project had been focusing on DNA evidence. And as their plan B, they had filed a Texas Open Records Act request for the DA's files and the sheriff's files from, I think it was 1987 and 1986. There were things like police reports of interviews with neighbors of mine where they all talked about seeing a van pull up behind my house on a few occasions and a man getting out and looking over our fence, kind of, checking out the place. If I'm not mistaken, there was one neighbor, I don't remember which one, that said she wasn't sure, but she thought she'd seen that van before and she knew where the guy lived. There was also a check cashed after my wife's death. A credit card, her credit card had been used in San Antonio. The most disturbing thing was what they referred to as the monster transcripts. This were the transcripts between my mother-in-law and the chief investigator in the case. And it was my mother-in-law talking about a conversation she had with my 3-year-old son. Now, we had had him to child psychologist, and it was everybody's feeling and conclusion that while it was a horrible situation, my son hadn't witnessed anything bad and nothing bad had been done to him. The only person he spoke to was my mother-in-law and my sister-in-law, and the gist of it was that he had witnessed the murder. He described the guy. He talked about my wife, his mother, calling for me, and my mother-in-law directly asked my son, if I was there, and he said no. And that's a huge piece of information that we should have had. I mean, that completely guts the state's case. Well, I've been asked many times about why. Why is a pretty big issue no matter what we're talking about. And why did this prosecutor do this? I sat through his 9-hour deposition, and I still can't answer the question of why he did this. He kept falling back on things like, well, that's something I would have done, but I have no specific memory of it because it was so long ago. We can theorize and try to figure out why he did this, but we're just Monday morning quarterbacking. I don't know, and until he starts talking about it, I don't know if we'll ever really know.
Well, it's a classic example of the prosecutor making up his mind right away as to what he thought happened, and then making the facts fit the conclusion he'd already reached. It's the reverse of course, what a good investigation and prosecution should be. And as a result, anything that conflicted with his view of what he thought the outcome should be and who was guilty was disregarded and not considered as something even that the other side had the right to. For instance, the young boy at 3 years of age, Michael's son, now we know was present during the murder, and he told his grandmother about it, and she tape recorded, and then she gave it to the investigating officer. He informed Ken Anderson and others. Ken made the decision that it wasn't admissible because he was 3 years old, and he thought the young boy was wrong anyway. So he didn't disclose it, and that was typical of the way a lot of prosecutors reacted to Brady in the 70s and 80s. If they didn't believe it was admissible, there was a strainer thought in some case law that indicated it wasn't Brady. If he didn't believe it, or if he thought it was just invaluable, not just not admissible, but didn't believe it, it wasn't disclosed. That went on for a long time by a lot of people.
Again, I think that case was a perfect example of law enforcement having tunnel vision. They thought they had their person. They didn't, and we can go into all the exculpatory stuff and leads that were out there. There was a green van that was spotted. There was somebody that said they could identify the person. They thought they knew where he lived. None of that was followed up. Tragically, less than a year later, another death occurred, and the MO was almost identical to Christine Morton's murder as well. So, I look back on it, what would have happened had Sheriff Boutwell and Ken Anderson, broadened their net and did a better investigation, but, it's tragic.
He was on the stand, and I asked him, I said, let me ask you, what's wrong with letting the defense have everything you have and be aware of it? And he said, then some defense attorney is liable to get a guilty person off. That's why you don't do it. In his mind, he was the guardian of the outcome, and therefore a fair trial where the other side knows everything might result in a guilty guy being found not guilty. But that's always the risk we've run in the name of fairness and openness.